Greetings, this is Christine Van Pelt on Gibson County, Indiana, State Coordinator and Lead Recording Secretary for the Indiana Assembly. Continuing with Brent Allen Winters, Declaration of 76, United States Constitution, a common lawyer, comments clause by clause. Alright. Section 2, Clause 3, the President shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. Comment. When the Senate is not in session, the President can make temporary appointments to offices that otherwise require the Senate's consent, nowadays called Senate confirmation. The Senate may later confirm or deny confirmation of such temporary appointees. Section 3, Clause 1. He shall from time to time give to the Congress information of the state of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses, or either of them, and in case of disagreement between them, with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. He shall receive ambassadors or other public ministers. Comment. This clause's phrase, from time to time, by custom, has come to mean that presidents deliver their State of the Union messages to Congress once each year. Though the clause only requires that the President give to the Congress information of the State of the Union, Presidents George Washington and John Adams delivered their messages in person. For more than 100 years after, however, most presidents sent a written message which was read to Congress. Then President Wilson delivered his message in person, as did Franklin D. Roosevelt and all other presidents since. Famous messages to Congress include President Madison's Monroe Doctrine address. During the 1800s, presidents often called Congress into session. Nowadays, it is in session much of the time. No president has ever adjourned Congress. He shall take care that the laws be faithfully executed and shall commission all the officers of the United States. Comment. This is called the Take Care Clause. No court has ever enforced this take care clause. Further, most Americans have never heard of it. During oral argument of the case United States v. Texas before the Supreme Court, the court asked the parties to address a question the parties never raised in their briefs: whether the Deferred Action for Parents of Americans, DAPA, order violates the Constitution's Article 2 Take Care Clause. DAPA was a set of executive branch directives giving some 4 million illegal aliens who have given birth to children in the United States what the orders call legal presence, even though their presence violates the law. This legal presence entitles DAPA beneficiaries to hold a work permit, a picture ID, driver's licenses, Social Security, earned income tax credits, Medicaid, Medicare, and other social welfare benefits. 26 states sued the federal government to challenge the legality of DAPA. The courts below held that the president's orders violate the Administrative Procedure Act because they were issued without public notice and comment, as is required for agency actions with the effect of law, and because they are in violation of the underlying statute, the Immigration and Nationality Act, INA. By adding the Take Care Clause to the questions presented, the court was taking care that the constitutional dimensions of this case will not be swamped by administrative law details. But for most people, including most lawyers, the Take Care Clause is uncharted territory. The Take Care Clause is part of the Executive Power Article 2. It compromises only 9 words. The President shall take care that the laws be faithfully executed. But an understanding of those 9 words requires an appreciation of their roots in English history. Like other features of our United States Constitution, the Take Care Clause derives from the long struggle between Parliament and the Crown over the extent of prerogative powers, that is, the monarch's asserted powers to create laws or otherwise to act unilaterally. King John, 1199 to 1216, was a major offender against the rule of law. He arbitrarily increased taxes, abused the king's court, mustered soldiers for military misadventures, foreign and domestic, and hanged innocents in Wales. Things came to a head in 1215 at Runningmead. Faced with armed insurrection, John agreed to the great charter called Magna Carta, which established the principle that the king is not a law unto himself. Even the king must act through settled law to bind his subjects. Folk called the king's legislative power the royal prerogative. The word prerogative signifies powers of executive that are not governed by law. John Locke defined the word prerogative in his second treaty on government. This power to act according to discretion for the public good, without the prescription of the law, and sometimes even against it, is that which is called prerogative. The king's prerogative powers included the veto, the pardon, the powers of war and peace, the power to create and fill public offices, and the power to dissolve the parliament. All these he could do without the need for Parliament statutes, and statutes Parliament passed could not touch, limit, or regulate these prerogative powers. Early controversies over prerogative power. Henry VIII believed his royal proclamations should have the force of law, as though they were made by act of Parliament. The 18th century historian and philosopher David Hume later called this a total subversion of the English Constitution. After Henry's death, Parliament repealed the Act of Proclamations. In James I's view, law does not restrain kings. Their authority, he declared, comes direct from God and not by way of the people, the militia, and therefore the king is accountable only to God, never to man or law. Chief Justice Coke, whose Whiggish constitutionalism later informed the views of American framers, held that the king could not lawfully change any part of the common law nor create any offense by his proclamation, which was not an offense before without Parliament. Coke concluded the law of England is divided into three parts: common law, statute law, and custom, but the king's proclamation is none of them. Chief Justice Coke reiterated the point in case of non obstante, or dispensing power. Coke observed that the king does have some prerogative powers. For example, a royal pardon grants mercy notwithstanding, or as English lawyers said at the time, non obstante, the lawful conviction. But Coke insisted that the king's non obstante, or dispensing power, never can be used to annul a statute. If the king attempted to dispense with a statute, Coke held, the king's effort would be voided. For an act of Parliament may absolutely bind the king. The principles of the case of proclamations and the case of non obstante are part of the American constitutional tradition. In the Youngstown sheet and tube seizure case of 1952, our Supreme Court's foundational separation of powers decision held that the president cannot make law. That is Congress's exclusive job. Hence, executive orders have the force and law only when implementing statutes, treaties, and the Constitution. That is, the sources of law the Supremacy Clause defines. Charles II and the suspending power. The most important struggles over prerogative during the Restoration period, 1660 to 1688, involved the suspension and dispensing powers, the power to suspend the execution of a law, and the power to grant dispensations or indulgences, permitting people or corporations to act in ways that would otherwise be harmful, notwithstanding or not obstating the law, as defined by a leading historian. The power to suspend a law was the power to set aside the operation of a statute for a time. It did not mean technically the power to repeal it. The power to dispense with a law meant the power to grant permission to an individual corporation to disobey a statute. The principal flashpoint in the Restoration era struggles over the suspension and dispensing powers of the question of religion. Charles II secretly and James II openly professed the Roman faith, which was awkward, given that the king was supreme head of the Church of England. At that point, dissenters from the Church of England were regarded as potentially rebellious and dangerous. In then recent memory, radical Protestants had overthrown the government in the English Civil War, and real or imagined popish plots were thought an ever-present danger to political stability. Charles and James sought legal protections for their fellow Romanists, but this was anathema to the Anglican-dominated Parliament. Rather than protecting Catholics, Parliament statutorily excluded them from various offices and jobs. On 15 March 1672, Charles II issued a declaration of indulgence, unilaterally suspending the penal laws against Romanists and Protestant nonconformists. Speaking in the royal first person plural, the king decreed, "We do declare our will and pleasure to be that the execution of all and all manner of penal laws in manners of ecclesiastical against whatsoever sort of nonconformists or recusants be immediately suspended, and they are hereby suspended." Charles II's unilateralism enraged Parliament, which forced the king to rescind the declaration. In its place, Parliament enacted the Test Act of 1672, limiting public office to persons willing to forswear belief in the popish doctrine of transubstantiation and to take communion in the Church of England. James II and the dispensing power. On his brother's death in 1685, James II assumed the throne, not willing to rely on Protestant militias and local gentry for protection against rebellion. He attempted to create a standing army and to place it under the control of the popish officers. To achieve this end, he granted dispensations from the Test Act, which allowed popelings to hold high civil and military offices, notwithstanding Parliament's legislation to the contrary. A parliamentary address responded that the Test Act can no way be taken off but by an act of Parliament. James then disbanded the Parliament, fired judges he expected to be uncooperative, and arranged a test case, Godden v. Hales. With one dissent, the court concluded that the kings of England were absolute sovereigns, that the laws were the king's laws, that the king had a power to dispense with any of the laws of government as he saw necessary for it, and that he was the sole judge of that necessity. Emboldened by Godden, James II suspended the ecclesiastical laws by issuing his own declaration of indulgence, that from henceforth the execution of all and all manner of penal laws in matters ecclesiastical be immediately suspended, and further execution of the said penal laws and every of them is hereby suspended. In 1688, James reissued the Declaration of Indulgence with the requirement that Anglican clergy read it aloud from their pulpits. The famed 7 bishops, Archbishop of Canterbury and 6 others, petitioned the king to withdraw the order, disputing its legality. James charged the bishops with seditious libel, alleging that the bishops falsely denied the king's power to suspend the Test Act and to grant dispensations from it. Remarkably, the king's bench split 2-2. The most ardent defender of the bishops was Justice John Powell. In explaining his vote against the king in the exercise of his dispensing power, Justice Powell observed, "Now, gentlemen, this dispensation amounts to an abrogation and utter repeal of all the laws, for I can see no difference, nor know of none in law, between the king's power to dispense with laws ecclesiastical and his power to dispense with any other laws whatsoever, or whatever. If this be once allowed of, there will need no parliament. All the legislature will be in the king, which is the thing worth considering, and I leave the issue to God and your consciences." With that spirited indictment of the king's dispensing power, the court sent the case to a jury. The jury, in turn, acquitted the bishops. When the verdict was announced, the people of London took to the streets in noisy celebration, which quickly turned into anger against James II and his executive overreach. Leading citizens invited the husband of James's eldest daughter, William of Orange, to depose James II and assume the English throne as co-monarch with his wife. The next year, in 1689, Parliament enacted English Bill of Rights, a list of principles of government that, along with Magna Carta and the Petition of Right, form the most important features of the British Constitution. The first two provisions of the Bill of Rights stated that the pretended power of suspending of laws or the execution of laws by regal authority without consent of Parliament is illegal. The second provision stated that the pretended power of dispensing with laws or the execution of laws by regal authority, as it hath been assumed and exercised of late, is illegal. Our Constitution incorporates British rejection of executive legislation. Consistent with the unwritten British Constitution at the founding, at least 3 states affirmatively outlawed and the suspension and dispensing powers prior to the U.S. Constitution. The Virginia Declaration of Rights of 1776, for instance, provided that all power of suspending laws or the execution of laws by any authority without consent of the representatives of the people is injurious to their rights and ought not to be exercised. When the framers met in Philadelphia in 1787, they too discussed the royal prerogative to suspend laws or grant dispensations. The delegates to the Constitutional Convention first took up the executive power plank of the Virginia Plan, Resolution 7, on 1 June 1787. Resolution 7 vested in the executive all executive rights that the Articles of Confederation had vested in Congress. Immediately, delegates worried that an unlimited grant of executive power would include the royal prerogative powers such as to make peace and war. John Rutledge, who arguably had been the most capable wartime state executive in the nation, wished to achieve the benefits of a unitary executive, though he was not for giving the executive the full range of royal prerogative powers. James Wilson declared that he did not consider the prerogatives of the British monarch as a proper guide in defining the executive powers. The delegates voted to vest the executive only with the powers to carry into effect the national laws and the power of appointment. 3 days later, on 4 June, the delegates debated whether to give the executive an absolute veto on legislation, one of the prerogatives of the crown that had survived the Glorious Revolution. Benjamin Franklin rose and expressed his concerns. The first man put at the helm of the presidency will be a good one. Nobody knows what sort may come afterwards. The executive will be always increasing here as elsewhere till it ends in a monarchy. The convention voted to allow Congress to override the executive's veto. Then Pierce Butler of South Carolina moved the question whether the national executive would have a power to suspend any legislative act for a term of time. Elbridge Gerry worried that a power of suspending might do all the mischief dreaded from the veto of useful laws without answering the salutary purpose of checking unjust or unwise ones. As Madison reports on question, for giving the suspending power, all the states were no. The very idea of a suspending power was unanimously rejected, never to be proposed again. On 26 July, the convention referred the executive power question to the Committee on Detail, which Rutledge chaired and Wilson intellectually dominated. These two delegates had expressed concern about executive prerogative on 1 June. The draft constitution at that point vested a single person with power to carry into execution the national laws. The committee changed this to read, "He shall take care that the laws of the United States be duly and faithfully executed." As a result, the execution of the law became a duty rather than power, as the word shall indicates. This effectively precluded any assertion of a dispensing or suspending power. The Take Care Clause's rejection of the suspending and dispensing powers is so unambiguous that even the executive branch has accepted it. The United States v. Smith, 1806, the defendants claimed the president had authorized their violation of the Neutrality Act. President Jefferson's lawyers countered that under the Take Care Clause, the president cannot suspend the act's operation, dispense with its application, or prevent its effects. If he could do so, he could repeal the law, and would thus invade the province assigned to the legislature and become paramount to the other branches of the government. Supreme Court Justice William Patterson, a signatory of our Constitution, agreed that the Take Care Clause explicitly denies the president a dispensing power. Later, President Clinton's Attorney General, Benjamin Civiletti, declared that the history of that dispute over the Stuarts' dispensing power was well known to the framers of the Constitution, and it is clear that they intended to deny our president any discretionary power of the sort that the Stuarts claimed. By framing the Take Care Clause as a duty, the framers rejected the idea that the president is vested with the prerogative powers of suspension or dispensing with the laws. When President Andrew Jackson argued that the Take Care Clause made him the sole judge of whether the laws were being faithfully executed, the Supreme Court responded in Kendall v. United States, ex rel. Stokes, 1838. To contend that the obligation imposed on the president to see the laws faithfully executed implies a power to forbid their execution is a novel construction of the Constitution and entirely inadmissible. The court added that this would be investing in the president a dispensing power, which has no countenance for its support in any part of the Constitution, and recognizing such a principle would be clothing the president with a power entirely to control the legislation of Congress. Take Care Clause bars president legislation. Apart from its subject matter, the executive action in this case challenged parallels James II's use of the dispensing power. The Immigration and Naturalization Act defines persons who entered this country without authorization and do not fall into any of its specific exceptions as being here unlawfully. That includes the beneficiaries of the DAPA order. Among the consequences of unlawful presence are ineligibility for work permits and for many social welfare programs. Moreover, the INA expressly provides that every day a DAPA beneficiary spends in the United States should accrue as a time under the individual's unlawful presence clock. These consequences were set by Congress for the purpose of discouraging illegal immigration, and unlike deportation, which necessarily involves enforcement discretion, these consequences are absolute unless there is an explicit statutory exception. These consequences apply to every person in this country unlawfully. Under the DAPA rule, some 4 million people unlawfully present in the United States under the statute were allowed to remain and to get work permits and social welfare benefits. Limitless executive power. Using hand-picked judges, James II won his declaration suspending the Test Act, and he used that precedent to justify ever-increasing exercises of executive power. The question, any further challenge of executive power to legislate is not whether the president's rule makes good policy. The question is whether our Constitution allows the president, any of Congress, exclusive power to legislate. It does not. Our Constitution includes the take care clause so that the executive does not legislate, but rather takes care that the laws be faithfully executed. Section 4, Clause 1. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Comment. What could be unbiblical about removing criminals from positions of authority within one's nation? This clause subjects all officers of the United States, including judges of the Supreme Court and lower federal courts, to impeachment, akin to grand jury indictment by the House of Representatives, binding over the one impeached to trial by the Senate. The phrase high crimes and misdemeanors embraces certain common law crimes that give the House jurisdiction to impeach. The language of the Constitution cannot be interpreted safely except by reference to the common law. Chief Justice Taft. Our Constitution is the clearest compactive expression of common law government available. Moreover, the common law, as it stood at the ratification of our Constitution, provides clear definitions of treason, bribery, or other high crimes and misdemeanors. In the past, the House has impeached federal judges and the Senate has tried, convicted, and removed some from office. In addition, the House impeached Presidents Andrew Johnson and William Clinton, but the Senate convicted neither of them. Impeachment in America has a colorful history. For instance, John Pickering, United States District Court judge and former Chief Justice of New Hampshire, challenged President Thomas Jefferson to a duel for urging his impeachment. Judge Pickering was a member of the Federalist Party. President Jefferson was determined to remove from office every Federalist judge possible by any means available. Thus, Jefferson accused Judge Pickering of wrongful exclusion of evidence in an admiralty case, unlawful dismissal of the same case, and swearing from the bench, all while drunk. By a 45-8 vote, the House of Representatives impeached Judge Pickering after his impeachment, but before the Senate began his trial, Judge Pickering challenged President Jefferson to a duel, declaring the right to trial by battle. Jefferson ignored Pickering's challenge. The Senate convicted the honorable judge in his absence on a partisan vote. See this handbook, U.S. Declaration of 76, Section 30, and comment. All right, that is all of the reading for this week, and I wish you peace and love.